You're not disputing that they were worth more than $200.
Yes.
This case isn't about a massive fraud, a violent crime, or a multi-million-dollar scam. No, today's courtroom drama starts with something deceptively small, a pair of headphones. But here's the twist. What begins as a simple act of property damage spirals into a criminal plea deal, police confrontation, and a debate over rights. On one side, we have Antonio Cornelius, the defendant who admits to breaking someone's headphones. On the other, the prosecution, pressing charges of property destruction and resisting arrest. The question is, how does a set of headphones land someone in front of a judge, facing jail time and fines? Stick with me because this case is about to reveal just how quickly minor disputes can escalate into criminal records.
Let's call the case People versus Antonio Cornelius.
Yes, Your Honor. I think this is Mr. Ward's case.
Marie Tanhouse, the prosecuting attorney, standing in for Mr. Ward, and Phil Owen, he's on his way.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, who stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
Zachary Ward on behalf of the people.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Your Honor, the defendant will be pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that. But it says the count 4, but not count 3.
Notice how the judge immediately flags an issue on the plea paperwork. This might look like a small clerical detail, but in court, the accuracy of a plea form is everything. If a plea agreement isn't crystal clear on what charges a defendant is admitting to, it could later be challenged or even thrown out. That's why the judge stresses, even something as simple as handwriting the correction would have been better than leaving it blank. This moment highlights a key lesson. In legal proceedings, details aren't just details, they're the foundation of the entire case.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that. The defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here to-
All right. It's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense, and also an added count 4 of attempted resisting and obstructing the 1-year offense. Upon his successful plea to those charges, counts 1 and 2 would be dismissed. And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor, that is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. Sure. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Here's where things get tense. Watch how Cornelius hesitates, giving one-word answers and forcing the judge to repeat questions. Judges expect defendants to be engaged and clear when entering a plea because once you plead guilty, there's no going back. His lack of responsiveness risks making it look like he doesn't fully understand, or worse, isn't taking the process seriously. In the eyes of the court, hesitation can raise red flags. What do you think? Is Cornelius just nervous, or does this show he isn't fully prepared for the consequences of pleading guilty?
Is that your understanding? Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these pleas?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges.
Yes, Your Honor.
Counsel approach, please. Record should reflect that we've had a bench conference in the Cornelius matter. I'm going to pass the matter briefly, let him have a conversation with counsel, and then let us know when you're ready and call you back up.
Thank you, Your Honor.
Court does recall the case People versus Antonio Cornelius.
Zachary Wood on behalf of the people.
Wow. Was that a sneeze or just a scream? That hurt my ears.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, he stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
All right, and I have had him sworn. And so we were in the middle of a plea, and sir, my understanding is that you wanted to take advantage of this plea offer, is that correct?
Yes, Your Honor.
All right. And you understand that you'll be pleading guilty to 2 misdemeanors?
Yes.
All right. First of all, this court's understanding you'll be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000.
This is the moment where reality sets in. The judge lays out exactly what Cornelius is facing, up to 1 year in jail and thousands of dollars in fines. And here's something many people overlook: property damage fines aren't limited to a flat number. The court can triple the actual value of the property destroyed. So those headphones? If they were expensive, the fine could skyrocket beyond the standard $2,000. This is why property crimes, even over something that seems small, can hit harder than you'd expect. Do you think the punishment fits the crime here, or is the system being too harsh?
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Also, that you'd be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty to these charges?
Yes.
All right. To the charge of malicious destruction of personal property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not at this time.
Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No.
Anybody threaten you or coerce you in any way?
No. No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 5th, 2025, at the location of 2281 Bonesteel Boulevard, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do regarding the personal property of a Jonathan West?
Here's the confession moment. Cornelius openly admits to breaking someone's headphones without permission. It sounds almost trivial when spoken aloud, but legally, that's malicious destruction of property. What's fascinating is his attempt to downplay intent, saying no intent of theft. The judge quickly cuts through that. Theft isn't even the issue here. Property damage is a standalone crime, and it doesn't matter if he planned to steal or not. What matters is that he destroyed something valuable that wasn't his. This is where a lot of defendants get tripped up, confusing intent with the legal definition of the crime itself.
Broke someone's headphones without permission.
Pardon?
broke somebody's headphones without permission.
Okay, so you got their headphones and when you say you broke them, what did you do?
Attempted to snap them in half.
Say again?
Attempted to break them.
Just break them?
Yeah.
Okay. And you didn't have their permission to do that?
I did not have permission to do that.
All right. And you didn't have any property interest in these headphones, meaning you didn't own them at all, did you?
No intent of theft.
Pardon?
No intent of theft.
He asked if you owned them. Or they were headphones.
Did not own the headphones.
Okay. And these headphones, are you disputing that they had a value in excess of $200?
Yes.
You are disputing that?
No.
Okay, so that, maybe I asked the question badly.
Now the case escalates. After breaking the headphones, Cornelius doesn't just walk away. He ends up in a confrontation with police. Notice how he admits officers grabbed his arm and he struggled. That struggle, even if brief, is what elevates the situation into a second misdemeanor, resisting and obstructing. Legally, even minor resistance, pulling away, tensing up, making arrest harder, qualifies. For viewers, this is a reminder of how quickly things can escalate once law enforcement is involved. What started as a broken pair of headphones is now 2 separate criminal charges. Would you say Cornelius overreacted here, or were the officers too aggressive?
I'm not disputing.
You're not disputing that they were worth more than $200,
Yes.
right? Okay, I just wanted to make sure. At some point then, did you come into contact with officers from the Ann Arbor Police Department?
Yes, said they were from the Ann Arbor Police Department. They may have had DPSS caps on.
Your Honor, they were using,
It was U of M?
Yes.
Yes, Your Honor.
So you came into contact with officers from University of Michigan Department of Public Safety?
Yes.
And what happened in regard to your interaction with them?
They grabbed my arm. I struggled after they grabbed my arm.
You struggled with them? They were grabbing your arm to arrest you?
Yes.
And you struggled with them either to make the arrest of you more difficult or to try to stop the arrest itself or to at least do something to obstruct what they were trying to do.
Yes.
Is that correct?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas, 2 counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
June 3rd at 9 a.m. before Judge Bell.
June 3rd, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
that's it for me today, Your Honor.
All right. Thank you. Good seeing you.
And there we have it. Antonio Cornelius pleads guilty to 2 misdemeanors, property destruction and resisting arrest. The more serious charges are dropped, but he now awaits sentencing with a very real possibility of jail time, fines, and probation. This case is a textbook example of how a single reckless action can spiral into a full courtroom battle. From paperwork errors to tense questioning, we saw every layer of courtroom drama unfold. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.